plaintiff's response to defendant's verified motion. So I do have that, sir. All right. And so if we need to refer to that, you have exhibits A through E with regard to that, some emails and some other information, it appears, attached.
Yes, Your
So at
Honor.
this time, Mr. Petanio, please proceed, sir.
Okay, thank you, Your Honor. As I said, I represent the defendants in this case along with Ms. Jeffers. Just some brief background about this case. This is a case that arises out of a car accident that happened back on August 20th, 2021. Plaintiff filed her original petition on March 23rd, 2023. And of course, we have trial scheduled for October 20th. We are moving for continuance on several grounds. The main ground is that there is a additional discovery and specifically expert discovery that needs to be done prior to trial. But as I laid out in the motion as well as the supplement to the motion, I have only appeared in this case on September 8th. The DCO was entered into before I appeared in this case. Another ground is we did take, or before I had appeared, plaintiff's deposition was taken on July 29th, 2025. She testified in her deposition that she had additional steroid injections to her shoulder about 2 months before the deposition, which puts that at about May 2025. We still do not have records regarding that. Plaintiff has a life care plan in the amount of roughly $1 million, which was reduced the present value to $855,000. That was done by Dr. Brandon Goff, Goff. Dr. Goff and Ms. Pierce, who did the present value calculation, they haven't been deposed yet. Dr. Goff is set for deposition tomorrow, but depending on what Dr. Goff says during his deposition, we think we need the opportunity to respond to that with our expert, who is Dr. Edward Pettyjohn. We received third supplemental disclosure from plaintiffs on September 19th, 2025, which says claims for attorney's fees and additional records. So we need additional discovery time for that. Another ground is the plaintiff is alleging, I believe, $325,000 in past and future lost wages, past $205,000 and future $120,000. The circumstances by which the plaintiff left her job leave a lot of questions as to whether any of that is due to this accident and should be even included as a damage component of this case. We did serve a subpoena, or Ms. Jeffers served a subpoena to the plaintiff's former employer, which is Robinson Aviation Company. That subpoena was served on August 13th, 2025, very soon after Ms. Keeling's deposition was taken, but we don't have those records yet. And so we need records from her employer to verify that this damage claim of $325,000 has anything to do with our accident or something else. And it's important because it's a huge component of their damage model. We also filed a supplement to that. I'm not sure if that has made it in there, Your Honor. That was filed on September 29th, 2025. We had filed a supplement to defendant's verified motion for continuance.
Yes, I have it.
Okay, thank you. So all that was raised in that was that we got additional records in plaintiff's fourth supplemental disclosure, which were served on September 26, 2025, less than a month before trial and after the expert deadline, with records from Plum Creek Surgery Center, Greater Austin Pain Center, and those records are important, again, to the defense of this case. The last thing is I had a email from plaintiff's counsel today before the hearing asking if we would, I guess, agree to strike or partially strike our experts' opinions on the billing, which, again, we are, a week and a half before trial. And if you want a motion to strike an expert, motion needs to be prepared, filed, a hearing needs to be set, and we need opportunity to respond to that. To go into trial and not know whether our expert can opine on, any of the medical bills from plaintiff until the last minute is just not fair. So we're asking for a reset of the trial date and an extension of the discovery deadlines in order to take care of these issues before trial in this case. And I would, and that's all I have, Your Honor, unless Ms. Jeffers has anything additional.
Let's defer to Ms. Jeffers and let her enter in, and then we'll turn to Mr. Shipp.
Yes, Your Honor. Samantha Jeffers, also for defendants, Devin Sims and Walk ATX. Just briefly, just to give a timeline to the court, Judge, July 18th of 2025, my office served discovery on the plaintiff, written discovery. We got into this case, I believe, around June of this year. Your Honor, plaintiffs responded to that discovery around August 18th of 2025. The plaintiff's deposition happened July 29th of 2025. And in her deposition, I did ask her about her lost wage claim. She could not pinpoint to me how much she was seeking in lost wages, but did in fact affirm that she was seeking lost wages as a result of this lawsuit. Shortly after that, on August 4th, is when we actually sent out a subpoena for aviation. I think Robinson Aviation was her employer. And so I found that out in the deposition, and we received confirmation from our record service that that subpoena went out on August 15th. So we did things pretty quickly there. To date, we still don't have those records. And those records are particularly relevant, Your Honor, because as co-counsel mentioned in Ms. Keeling's deposition, she did mention that she was seeking lost wages, but she also told me that there were various reasons as to her departure from her employer. And so I asked her who her supervisor was, if there were any documents that were relevant to her departure, and she affirmed that there were. And so that request is to get insight into those documents to see what the reason was for Ms. Keeling's departure to assess her lost wages claim. Also, Your Honor, I'd like to point out, as I'm sure the court's aware, Rule 194.2 requires disclosure of any amount or calculation of economic damages. Now, I combed through plaintiff's disclosures, their original disclosures, and then there are supplemental versions all the way from version 1 to version 4, their fourth supplemental that my co-counsel just mentioned. Now, Your Honor, in all of those disclosures, except for the fourth, which was served outside of the discovery period, that's the first time that there were any earnings mentioned in the disclosures. So supplemental 1 through 3 did not mention any earnings. And as I mentioned, the plaintiff could not tell me how much in lost wages she was seeking at the time of her deposition. And then, Your Honor, in regards to the medical records, just briefly, Judge, there are 2 facilities that were named in the medical records that we recently received, I believe last week, around the 26th or the 29th. One is Plum Creek, as co-counsel mentioned, and the other is Greater Austin Pain Center. Your Honor, again, I combed through all of plaintiff's disclosures from the first supplemental to the fourth, and Plum Creek is not mentioned anywhere in those disclosures. I understand that that's a surgery center, and I believe an injection was received by the plaintiff at that facility, and we, quite frankly, deserve the right to request additional records from that facility to see if she treated there before and the extent of her treatment with that facility. Again, Your Honor, as I mentioned, I combed through disclosures and I could not find any mention of Plum Creek, and I'm happy to have opposing counsel correct me if I'm wrong. Lastly, Your Honor, the last thing I'll mention is that in regards to plaintiff's fourth supplemental disclosures, there's a section in there that asks about any mental anguish, things of that nature, as I'm sure Your Honor has seen before, and it details that plaintiff will supplement that information. Now, as I'm sure the court's aware, this is set for trial October 20th of this year, so just in a few weeks here. And quite frankly, it troubles me that that still says will supplement. We're past discovery, we're nearing trial, and if there is responsive documentation to that disclosure, then plaintiff needs to produce that.
Okay, and have you gotten any feedback on the one subpoena that you mentioned early on in this, in your comments? You sent back, have you gotten, on her employer, have you gotten any idea of when you can expect those records?
I can, Your Honor, and I believe what I do with my paralegals, I kind of send like a tickle message. I don't have the list of communications with Lexitas that my paralegal would have that, but I can definitely double check that. Usually, in our experience, employment records are a little bit, I'm sure your honor is aware, employment records are a little bit more finicky than medical records. And in addition to, so I can always double check with Lexitas and check the status. We have not received anything saying that any authorization is needed or anything like that. Usually that would come right to me and I would have to obviously let opposing counsel know and go from there. In the midst of those records too, plaintiff mentioned to me in her deposition that there were a lot of police that were on the scene. So we did request APD body cam footage and things of that nature on that same date. But in regards to employment, that's really, I think, the most important here. I can always double check with Lexitas to see the status, but employment
Well, I
records.
mean, you haven't received an objection, you just haven't received anything.
That's correct, Your Honor.
Okay. Mr. Shep, we're to you, sir.
Thank you, Your Honor. So, as defense counsel has mentioned, this car wreck occurred over 4 years ago. Lawsuit was filed in March of 2023. And while I understand that defense counsel has just formally appeared in this case back on September 8th, 2025, if you'll take a look at Exhibit A, you'll see that since at least January 22nd, 2025, defense counsel has been aware of this case. Since I think they were aware of this case, or I know they were aware of this case since that date, I don't think there's a valid excuse for them to have waited until September 8th to formally appear, Your Honor. We're ready for trial, issued our trial subpoenas, have our experts ready to appear live to move forward. The plaintiff has been waiting, over 4 years for resolution here. And like I said, we are prepared to move forward. With regards to loss of earning capacity, we did produce a report from a vocational expert, Ms. Pierce, who details Ms. Keeling's loss of earning capacity. Her life care plan, which was provided to defense back in April of 2025, shows the future mental health care plaintiff will need and the costs associated with that. We have additional exhibits as well, Your Honor, if you would like me to go through a couple of those.
I have your motion up, your response up on my screen. I obviously haven't put it on share screen for everybody, but I have it pulled up here on my screen. Is there anything you want to draw my attention to?
Yeah, in our motion, Exhibit B, we have Liberty Mutual, an email from the adjuster basically saying that, hey, defense counsel has already been appointed back in July of 2025, but again, didn't appear formally until September 8th. Exhibit C is Mr. Petanio ordering a copy of the plaintiff's deposition back in July, but again, didn't appear formally until September 8th. Mr. Petanio as well, he joined us in mediation back in August as well, Your Honor. So I just don't understand the waiting until September 8th and now delaying this trial.
Okay. All right, I'm looking at Exhibit C. What do you have through E?
Yeah, E, that was in regards to Dr. Goff's deposition, where my firm had sent a handful of, or 3 emails over to defense counsel, but got no reply. And with regard to the scheduling of his deposition, that has since been rectified. His deposition is set for tomorrow.
Okay, well, what about the other arguments that they've raised with regard to anything from the employment records to the as far as the reason for discharge and whatever other reason, rationale might have been with regard to it, plus the your open-ended, we will supplement on a response you gave within the last few days.
Yeah, Your Honor. So with regards to her not being able to work anymore, she couldn't handle the drive in the sitting. She testified, Ms. Keeling, the plaintiff, testified to that in her deposition, Your Honor. I think it was a 4-hour drive to her place of business as an air traffic controller in Houston. I believe she was driving from Blanco, Texas, and was unable to do the drive anymore due to the pain she had when sitting down for long periods of time. And again, testified to that in her deposition. With regards to attorney fees, we're not seeking those. We have amended and excluded those from our damages. If the injections that opposing counsel is referring to are for her shoulder is not at issue in this case. It's her neck and her back, Your Honor. This case has nothing to do with her shoulder. That was a different injury.
Now, you talked about, apparently there was a supplemental that I believe Ms. Jeffers mentioned about mental anguish.
Yes, Your Honor, that is
It
addressed in
says
her.
we will supplement in your fourth disclosures.
I'm not looking at that right now, but I know our mental anguish and mental health care that's recommended for the plaintiff is laid out in our life care plan again, which was produced back in April of this year. Our expert has put all those damages together for us.
Okay, Ms. Jeffers, you seem like you have something to say about that. You leaned in.
Yes, Your Honor. Thank you very much. Just briefly in regards to the serving of expert reports, Judge, their opinions and what plaintiff is seeking in this lawsuit can be very different. So like opposing counsel mentioned, that expert report that was received from their economist that opined on the lost wages and earning capacity, that was served, I believe, in June. Now, I took plaintiff's deposition July 29th of this year, and she had no idea how much in lost wages that she was seeking despite that report being in existence. And that just goes to say that simply because there's a number noted in an expert report, that doesn't necessarily correlate with what the plaintiff is seeking. And that's the point of the 194.2 disclosure, so that we have some idea of what she intends to argue and seek at trial. And Your Honor, in regards to the testimony, and I don't want to waste the court's time, I have the page and lines here. Plaintiff in her deposition, she testified that there was COVID-19 and there were other reasons, and she just couldn't handle the commute anymore. So the reason for her departure, she testified already, will be in those documents from Robinson Aviation, and those are directly relevant to her lost wages claims, and we need that information.
All right. Back to you,
Judge,
Mr. Shue.
may I be allowed to speak? I know this is David's here.
Yes, sir. Mr.
In her
Flater.
deposition, Mr. Aaron Von Flatern for the plaintiff. And in her deposition, Ms. Keeling testified very clearly that she couldn't do the drive. That was the issue. When asked whether she told her employer that, she very transparently testified, probably not, meaning that these employer records are going to show what she's already told them it will show, which is that she did not even tell her employer she was in a car wreck. And that's something she's freely admitted. She's never tried to hide that. She is an air traffic controller, a very by-the-book person. She could not do the drive anymore, and she's simply told her employer that she couldn't do the drive anymore. Now, privately, she couldn't do the drive anymore because of her back. She did not share that information with her employer, and she's made that clear. So this is, to me, a fishing expedition. And as for the idea of expert discovery being open, expert discovery is closed as of the disclosure deadline. What we're doing now is compiling trial testimony. So, for example, Dr. Goff is going to testify tomorrow out of convenience. You know, we could bring him to trial, but it's better to get it in the can, make it easier on everybody, including the court and the jurors. There's no new opinions even allowed to come in. So the idea that Dr. Goff is going to say something that they have to respond to is not true. Dr. Goff had a duty to disclose his opinions by the disclosure deadline, and he did so. So they know how to respond, and they can bring their experts to respond. Third, Dr. Pettyjohn he is an orthopedic spine surgeon designated to contradict our orthopedic spine surgeon. He made some stray comments about billing. He is not a billing expert, has zero credentials as a billing expert, nothing in his CV. They have a billing expert. So the idea that we're asking to strike their billing expert or something like that prior to trial is not true. What we've asked is that these stray comments not turn into opinions in court from someone who has demonstrated no credentials or qualifications whatsoever to make those stray comments, which were attacking our life care planner.
Your Honor, if I may, briefly.
Yes, ma'am.
Just briefly, in looking at the medical records that were untimely produced at the last minute, those mentioned chief complaints of neck and back pain. I know Mr. Shute mentioned shoulder injections and things of that nature. I'm looking at those records and those specifically are in reference to neck and back pain and treatment, which is what opposing counsel just mentioned that plaintiff was having trouble with and why she couldn't drive back and forth. I do again have the deposition testimony, and she specifically says that there are a plethora of reasons. And again, if I could share my screen, I would, if Your Honor would like, but I do have that testimony available. And in regards, I wasn't on the email correspondence about Dr. Pettyjohn and his opinions, but if it's an attempt to strike his testimony, the plaintiff counsel had his report, and there was also a deadline to strike any opinions in that regard as well.
And Mr. Van Flandern, let me just ask you real quick, with regard to Dr. Pettyjohn, is that not more appropriate just a motion in limiting with regard to, as opposed to strike? Isn't that a less, I'll call it a less offensive approach?
Yeah, Judge, and to be clear, I didn't say that I wanted to, well, let me clarify. I asked Mr. Petanio whether he'd be willing to withdraw that part of his opinion in light of the fact that it's just inadmissible evidence. So, you know, whether we've met a deadline to challenge an expert or not, the rules of evidence still apply in trial. And if we've slept on that deadline, and I think defendants will agree they've slept on some others. So, you know, we said, look, we should have filed something before, but these comments are just wholly inappropriate. And we just don't want them to come into court. If they do, it's going to be a problem for everybody, including, you know, whichever judge is sitting on this trial.
Okay. All right, Mr. And I'm sorry, I'll mess it up again. Petanio?
That's okay. Yeah, correct, John. I don't have anything additional to add. You know, it's one thing for an expert to say something, but it's another thing when the plaintiff herself says it, specifically with regard to the lost wages. And so, you know, that needs to be further investigated. And that's all I had, Your Honor. Thank you.
Okay, Mr. Shoup, let me, everybody else has jumped in. It's, we'll come back to you, sir.
I have nothing, nothing further, Your Honor. Thank you.
Okay. All right. Then I'll just make sure everybody's said their piece. Mr. Petanio, you resolved everything I need to know. You've told me.
Yes, Your Honor.
All right, Ms. Jeffers,
Yes, Your Honor.
Mr. Shupp,
Yes, Your Honor.
and Mr. Van Flandern.
Yes, Your Honor.
See, I got the Von in these times, the
You
last
got
two
it.
times. Yeah. So anyway, all right. One thing I want to do real quick is I'm going to take a quick look at the exhibits that are on your response because I haven't had a chance to read through those. I got this notice of this. Ms. Seeger was wonderful about getting me the notice on the case, but we had all these other cases to look at as well, and then they vaporized before you guys came in. And so it turned out that the amount of time that I'd allocated to those, I could have spent looking at y'all's stuff a little better. And so I want to go back and take a brief review. I've looked at, but I haven't gone and looked at the response. But I will. I tell you what, it's 2:35. I will have Ms. Seeger send you a response and a ruling by 3:30. Okay.
Thank you,
We're not
Judge.
going to drag it out. You'll know something by 3:30.
Thank
Okay.
you, Your Honor.
Thank you,
All
Your
right.
Honor.
Thank you for your time.
Thank you.
Have a good day,
Thank you.
Judge.
You too. Well, Janice apparently they wanted you. So all for whatever. You're muted, however you were.
Sorry, I'm glad they wanted me
You're good.
since I
And
wouldn't.
I've got to ask, Pam,
Appointment.
have you done something different with your hair, or is it just the camera? Your hair on my screen is bright purple.
You talking about mine or Janice's?
Yours.
Mine. You know, I thought when you said that, at first I thought you were talking about Janice, but then when you said mine, when you said purple, because my niece, we used to have some Zoom calls. We were in the process of selling something and we were doing with the real estate agent. She took a picture and sent it to everyone. And she goes, Aunt Pam's hair is purple. And I don't know why it looks.
I mean, Janice, I can see the highlights and the whole bit with hers. It looks fine. Mine looks as gray as ever. Grant's, of course, sitting in the dark, so who can tell?
And I know,
But-
by looking at, yeah, I mean, I just had it colored a couple weeks ago before but I don't know, it does kind of have a purplish cast, which kind of embarrassing.
Well, yours is very clearly plum colored on my screen, so
I guess I
yeah.
should wear purple to go with it. But yeah, I'm looking at it now, and maybe I used to not blur the background because I don't like how it looks, but then I have all this crap behind me that I didn't want to show.
Right.
So
Well, see, don't you have
none
the
of the
same?
staff they've been nice and not told me that my hair looked purple.